Okay, so I just want to get right into this. We're not going to do this as presentations. We're just going to do a conversation. These are people who I think are probably best placed to answer these questions, or at least to frame them correctly. And I just want to start with the first question in my mind, which is whether in the markets for consumer goods, authenticity is framed as a measure of the inherent characteristics of the good. So is authenticity about what the good is? Or rather, is it about something else, like provenance, for example? Or is it something else, like rarity, for example? So I want to take this in a couple of pieces. Mark, can you get us going by talking a bit about the first part? Is authenticity a measure of the inherent characteristic of the good or something else? And then there's a related question, which is who decides? Is the decision made by consumers? Or is it essentially like an authorship question where the decision is made by some institution? And maybe, Sari, you could get us please started on those questions. So Mark, please take it away and we'll go from there.
Well, so first, thanks for having me. Chris, I thought your comments when you were talking about Vitra earlier actually kind of set the table for this really well, which is, I think many of the disputes that people have about whether something is authentic or it's fake basically take that exact set of dimensions that you're describing, which is, do we decide whether something is authentic by asking questions about the nature of the good itself, right? Do we ask about some inherent characteristics? Maybe GIs would be a really good example here, right? Can we tell whether a wine is authentic just by asking people to drink it, right?
Yeah, so just for everyone on the same page, GIs are geographical
indications, yeah. Right? So, there's this famous Judgment of Paris, right, where people get and they drink these wines, and it turns out that the fancy judges from France can't tell, right, whether the wine is produced in France or in California. And in fact, the California wines routinely win, right? And so, one sort of way of asking questions about that is to say, well, like if there are no tangible characteristics of the wine that are discernible, right, that you can actually tell the difference, is authenticity established, right? Or should you not care in that circumstance? And of course, the French winemakers say, yeah, but there's like a sort of intangible characteristic that it has to do with its terroir, right? Where it comes from, which maybe is not reducible to anything that you can measure. Like maybe you can't taste it, maybe you can't, but it's like, it doesn't matter. It's sort of like an inherent characteristic, which is sort of like saying, is there an authoritative person or entity that in order for something to be authentic, it has to claim it, right? It has to say it comes from us. So I sort of interestingly, I mean, not to sort of anticipate too much, but like trademark law very much takes the latter form, right? It very much takes the form of authenticity is about denomination of source, the denomination of the entity that creates it. So much so that, the trademark owner can radically change the composition of the product. And that doesn't matter at all, the doctrine, right? It's only a matter of who stands behind it. We don't ask any questions about the sort of composition of the product itself. And so I think the who decides question on the trademark side is very much bound up in the entity producing it. Julie would probably have lots of these kinds of examples, but tons of stories about luxury goods companies, that produce products on some line in China, and then they turn the lights off. And then they turn the lights right back on. They produce exactly the same product with exactly the same characteristics, exactly the same, but they're no longer authorized, right? Because they're now after the production run, and we treat those like counterfeits, right?
So sorry, Mark was talking a bit about who makes this decision before a product enters the stream of commerce. So what about after a product enters the stream of commerce? Does that change this question of who decides?
So I think it's important to start from the foundation of trademark law, which is that it presupposes that what consumers care about is authenticity as to source primarily. But people act in capacities outside of just being a consumer. Consumers care about more than just the source. And consumers use trademarks just in common language, engaging in a culture. And I have a couple of images as examples I wanted to bring up.
Michael will cue those up and
Okay.
give you this.
Yeah, so this bag of chips, I hope you could all see it. There's a lot going on here. There are a lot of things that could be trademarks. There are a lot of questions we could ask about authenticity, about what consumers should care about when they look at this product. I care that it's a chip, right? I might care that it comes from Wrap Snacks to the extent that that says something about the quality of the chips. But do consumers care about whether this is authentically involved with Nicki Minaj? Like, what's Nicki Minaj's role here? And we also see Barbie. Do we care whether Barbie has a real affiliation with these Wrap Snacks barbecue truffle chips? Maybe not. And what I mean to suggest with this example is it might be time to revisit trademark law's assumptions about consumers caring about authenticity as to source, either alone or predominantly. And that takes me to Chris's question about aftermarket goods and customization. So there's loads of sneaker art customization happening right now on what were authentic Air Jordans, authentic Air Force Ones. We need not really question that those came from the maker, but there are certain uses of counterfeit shoes. But putting aside that issue of whether the underlying shoe is counterfeit, assuming it was an authentic Nike shoe purchased from Nike, and then an illustrator takes it and draws meticulous images on it, hand painted, customized to a particular customer, or just based on whatever they want to represent on that shoe. It requires us to revisit the question of what consumers care about. Authenticity as to what? Authenticity as to the art that appears on the shoe? Does it make it not an authentic Air Jordan anymore because an artist came and drew these meticulous illustrations on it? So there's just so much more complexity now in terms of how people are interacting with brands on a daily basis, whether it's as consumers or as creators, that it challenges the assumptions we have about how trademark law cares about authenticity. Maybe it pushes it to keep a pace with how people are actually interacting with brands now.
Okay, great. So Julie, based on what we've heard so far, what do you think are the concerns or values in the markets for consumer goods that the concept of authenticity is supposed to respond to? So I guess I would put it this way. In the world of consumer goods that we know, we don't really have a scarcity problem in the old-fashioned sense, right? So Birkin bags are rare, not because cowhides are rare. Birkin bags are rare because they're made rare. So we don't have a natural scarcity problem. We have a manufactured scarcity phenomenon. Natural scarcity is what this question of authenticity ordinarily responds to. So in a world that doesn't feature natural scarcity, why are we so focused on the question of authenticity?
Yeah, so I agree with you on all fronts, save for maybe Himalaya, Birkins, and Kellys. We might be able to make the argument that those crocodiles are potentially rare, but they could just breed more. And buy more farms, which Hermes is regularly doing. And I think it's fair to say, yes, with some exceptions, we're really not dealing in natural scarcity. We're not talking about, semiconductors and chips and stuff like that. We're talking really about manufactured scarcity. We're talking about the creation of scarcity, which is really at the heart of the narrative that luxury brands are so dependent on, what their luxury positioning is dependent on, what their pricing power is dependent on. And really it consists of a few things. We're talking about creating this image of craftsmanship, of exclusivity. And when it comes right down to it, it's not real. Even the luxury goods that we think are manufactured in relatively small amounts, Birkin bags, for instance, there's more than 1 million of them in circulation. As of a few years ago, they were making 70,000 or more of them per year. And so it really is, I think, a reflection of the marketing gusto and spending that luxury brands are willing to put behind this to get consumers behind the idea that they're buying into something that is kind of scarce. And I think Ferrari's late chairman put it really, really well in saying, we work really hard to balance this and we make one less car than demand requires. So the supply is just a little bit short of demand. And that I think is really kind of a testament to, or is really demonstrative of the scarcity that we're talking about here.
So can I push people to talk about this a little bit more? Because that really strikes me that demand is carefully measured and carefully, petered out or metered out, I should say, to create a bit of desire, but obviously not too much, because if they're making 70,000 of them a year, right, it seems like most people can have one if they can afford one. Okay, so I understand why a luxury goods company might want that. It enables them to charge a higher price than if the supply were greater. Why would anyone else want that? So what interests of anyone does this particular way of thinking about authenticity serve?
So I guess let me start by distinguishing between authenticity and rarity, right? So authenticity doesn't necessarily imply rarity. It could just mean they all come from a single place, even if those things are massively produced, right? And so very conventional way of talking about that in trademark terms would be to say, for lots of goods, the empirical way of assessing authenticity by actually evaluating characteristics is like impossible for consumers to do, right? They don't know how to evaluate the quality of shoes. They just rely on the presence of the Nike mark to give them that information, right? It's a very sort of search costy way of talking about trademarks. What's interesting about having this conversation now, of course, is like as we move into a world where certain kinds of authenticity might be able to be guaranteed through NFTs or something on the blockchain, that concern about consumers' inability to assess authenticity is actually probably disappearing, right? At least with respect to those things, because the authenticating information can be carried with the good. You might not need the marks to do it anymore. And so I think there was a conventional way of answering that for a long time, which is that authenticity was a way of guaranteeing something about characteristics that you couldn't directly evaluate. Interesting question is whether that still holds.
So can I jump in?
Yeah, Christine, please.
I guess I'm with you all to a point. But I think we're collapsing authenticity and authorized in a way that's a bit dangerous, right? So I think we're talking about two things. We're talking about authorized goods and their claim to be authentic, right? And their marketing and sale of authenticity as a concept. But they're not, but that's not in and of itself, that doesn't make it authentic, right? And I guess I'm also a little bit skeptical of this understanding of trademark in terms of a consumer reception as indicating the who of, where it comes from. I think that, consumers have no idea, and if pressed, and it's not, I don't know the name of the manufacturer. I mean, like literally, it is a million, entities away from the who they think it is, where this good has come. And, the example of that you gave of turning off the light and producing more, it's so detached from the who. So I think, if there's any value to consumers of the authorized trademark, it should be about the intrinsic qualities of the goods, that at least it could come from many who's and never the same who's, but there is some consistency in terms of that intrinsic quality, or the composition or the method or something should be stable in order for that information to have any purchase at all.
I totally agree with that, except just to remark that, of course, trademark law doesn't require that stability at all. Right.
But it talks about it,
yeah,
right? It never,
right.
right. It never holds their feet to the fire, but they
Right.
talk about it as if that's a real
Mark,
thing.
could you tell me a little bit more about how it pretends? I just want to make sure we understand this conversation,
I
where it
mean-
ends up in current law or current policy.
So I totally agree with Christine that, like, in sort of the theoretical story that we all tell, right? The part of the information you get from a trademark is some kind of continuity of goods, right? And we talk about that as an incentive all the time. You want to make sure that you're giving companies incentive to maintain consistent quality. It doesn't have to be high quality, just sort of consistent over time. But we all know like tons of examples of companies that radically change the composition of the product. They radically change characteristics. They might make it in a totally different place, right? So if to use another geographical indications, example, you might know that the story of Super Tuscan wines, which are basically a break off from, I think it's from the Barolos. And the reason was because they wanted to make that with a different composition of grapes. And the Barolo people are like, no, you can't possibly do that because it's essential to it being a Barolo that it had this mixture of grapes, right? Fast forward 20 or 30 years, it turns out that the Barolo people adopted exactly the inverse proportion of grapes, exactly the same ones that the Super Tuscans had done. The thing that they said was essential to it being a Barolo, they abandoned because it turns out people liked the other wines better, right? So the point is that like there need not be, and trademark law does not require anything about the consistency of the goods. It's just part of the story we tell about like maybe the incentive is that.
So we have a lot to talk about in a variety of different consumer goods markets, but can we just focus on wine for a second? I'm going to
I
say
have
that.
a bottle right here.
I'm going to
We
say
could-
that tonight,
So-
actually. Can we just focus on the wine for a second? But before we focus on wine as a thing, I want to focus on wine as a concept, which is, so take Bordeaux, right? So Bordeaux has a GI, well, many GIs associated with it. And Bordeaux also has a kind of characteristic mix of grapes associated with it, right? So there are grapes that are used in Bordeaux, and there are some traditional techniques that are used as well. And one might imagine a wine produced in Sonoma that uses the traditional mix of grapes, virtually all of which I think are grown in California as well, and which uses the traditional vinification techniques as claiming to be a Bordeaux. That is not the world we have. So could we talk a little bit about the world we have and then why? So why do we have a particular framing of authenticity that applies to wines, that applies to spirits, that applies to cheeses, for example, that is rooted in place and not in recipe or, technique? Does anyone want to step forward? But I'd love to hear what you
Chris,
guys
as
think about this.
problematic as that is, I can't help but think it's a stronger claim than any kind of authenticity claim with regard to the consumer goods that I think we were more readily thinking about.
So why
right?
is it
So-
stronger?
Because at least there's a claim to the authority comes from the claim to the land, which, in most cases, there's some firm boundary. But when we think about authenticity with regard to a mass-produced consumer good, that authentic claim is very vulnerable, right? And this is, what we've been talking about how it is somehow claiming some kind of heritage, some kind of lineage, which might go back to a artist, right?
Right.
And I think that, that's much less stable. than-
So we'll focus on one, but this comparator, maybe a good way to focus on it is to get the comparator out on the table. So one comparator might be what we talked about earlier, which is, chairs. So there is a authenticity story being told about certain chairs or certain tables. Can you talk a little bit about that? And can you talk a little bit about what you think are the strengths and weaknesses of that authenticity framework and what it's there to do?
Can I talk about lights as well?
Sure. Lights, yeah,
All right.
definitely.
Just a little bit of an interesting story, which I think makes this point very well. So I've been writing about mid-century modern designs, and when these, which is, kind of like the really the kind of, glorious time, most glorious time of industrial design. When these designs came out, there were no intellectual properties to speak of, right? There were a couple of design patents out that didn't really ever get used toward any productive means, and most people didn't get them, so there were no rights. And it was at this time that the companies who produced these designs started to reach towards authenticity. And so the example that you gave earlier about the Eames lounge chair, that design came out at least, more than a decade after some of the other designs have come out. And by that time, Herman Miller was well-versed in the fact that it didn't have any intellectual property and that there were lots of copyists who were going to copy everything they did. That design was different from the designs that had preceded it because that design was meant to be kind of a high status design.
Right.
So the materials used in those lounge chairs, they were leather, it was rosewood, it was meant to be a status item. And that design was marketed as Charles Eames, right? So he was marketed. And so this, kind of reach toward, this, authority comes from the author, right? And we are Herman Miller, we are directly linked to the author. Most of these designs, went out of production in a couple of decades and were abandoned in the sense that there were any rights to start with. And then some companies came on the scene, like the company Modernica in California, and they went and they bought the machinery from the original producers who were not Herman Miller, who was not another company, but a subcontractor of a subcontractor. They bought the original materials. In the case of the fiberglass chairs, they bought, I think, like 12,000 of the seats that had never been put together with the bases. So they had the authentic pieces, and they produced them with the same materials and the same machines. And they were the only ones selling these things, plus lights. Those were marketed as the authentic good until Herman Miller found a way around that through various means, litigated, and now Herman Miller is the authentic producer and the only producer. And if you buy almost anything in this vein from Herman Miller, it will come with a certificate of authenticity. But most of those designs have been altered, right? They've made modernizations. People are now bigger. So the dimensions need to change, the materials need to change, the processes is modernized. And so in some ways, the authorized version that comes with a certificate of authenticity is far less authentic.
Yeah, it's interesting. So that wine has changed too, right? And this is, there's a story of continuity that is told about place, just like there's a story of continuity that's told in furniture about heritage and an author. Often continuity is a little bit oversold, right? There have been some changes. The Super Tuscan story is a great story. Barolo is a difficult wine to like unless you spend a ton of money and wait a ton of time for it to soften up. Super Tuscans are very friendly, right? So they were appealing.
Turns out they taste a lot more alike now because they just redid the formula.
Yeah. But I am really interested in this idea of like, what other stories could we tell? So if you were in control, Christine, of the authenticity story in furniture, if you were the person deciding, what story would you tell? What story would you want to tell?
Oh, can I show slides?
Yes. I can cue yours up and.
I just have one thing while we're waiting for her to get the slides up, is I just as an observation, which is one, surely not the only one difference between at least the authenticity story claimed by producers of wine versus in the design context, which I think is a great comparator, is that the wine producers at least feel the need to tell that story in a way that is reducible to some characteristic of the wine itself, right? It might be a made up one, might be mysterious. It might be that the land actually isn't like a real characteristic, but they say it is, right? They say that the terroir is like an irreducible feature of the wine and that it can't be reproduced in another place. Whereas the authenticity story that's made about design is not actually about the physical characteristics of the product at all. It's about the intangible design as such, right? So it's dematerialized in that way.
So the design story I'd want to tell is, so here's an example of the marketing, right? Beware, you're looking for the real things, could be not more perfect for our conference, this old, and you see the Eames lounge chair there. So the design story of the George Nelson light, and I am having trouble making this move. Oh, can we go back? So George Nelson is famous for the bubble light, which now Herman Miller makes. And the reason he designed that bubble light in the first place is because he really, really, really wanted one of these lights. And so in the early days, before authenticity was marketed by Herman Miller, he told his story, which was he said, if I could get one of those Swedish lights in my studio, I would look like I was really it. A pillar of contemporary design. So he wanted it for status symbol. It cost $125, which was out of his price range. And so he, oh, it works. Thank you. And so he came up with the idea to use a much cheaper material, a much cheaper method of manufacture so that he could produce a light that cost $12. Now, he didn't come up with this design. It was another artist in his studio who came up with the design, but it was marketed always as his. And so it was because he was in an era where these designers were trying to solve problems, which is to make good design available for everyone, right? They were trying to use materials and to use production methods that had no artificial scarcity, but could be bought by everybody, could be made quickly, could be made cheaply, served a lot of purposes. So that now to have them sold with certificates of authenticity is like quite ironic. And just to show you what the Modernica, so Modernica was the one who was making these lights. So even they, are some claim to heritage, these 30 years we revitalized. I think that they did revitalize it, but yeah.
Okay. So could we just move a little bit back to some case studies of how this works out? So Julia, I recently had been reading about this StockX case, and in particular, also cases involving the RealReal and this question of authenticity. So could you talk a little bit about what the authenticity issue is in those cases?
Yeah, I mean, I think to some extent it depends on who you ask, what the authenticity question is and kind of what is at issue. But I think, if we're thinking about the cases that Chanel filed against the RealReal and against what goes around comes around, which are still underway, we have Chanel taking issue with the sale of quote unquote inauthentic, infringing goods, based and asserting trademark related claims for that. But then Chanel also makes some false advertising claims, which I think are really kind of the very interesting element of these cases. And basically saying that, by the RealReal, let's take them for example, by holding yourselves out as authenticating these goods and offering up goods that are 100% authentic, a claim that has since disappeared from their website, you are misleading consumers, and really you're not in a place to make those claims because your authenticators are not trained by Chanel. They don't have our insight and our tools to make such claims, but also, you're building a business around claims of authenticity that we're really not sure, or we are sure that you cannot make. And the RealReal has said that's nonsense, and potentially rightfully so. And also says that, if that is the way that we're going to do business, it really puts resellers in a difficult position, because a lot of what their business is based on is being able to claim that they're selling authentic goods. That also ties into StockX, because the somewhat of similar claims, I think, are raised there. Originally, StockX or Nike filed a lawsuit against StockX over its NFTs. It didn't originally make false advertising or counterfeiting claims. It added those after the fact. But even from their original claim, they were making arguments about should StockX be claiming that these products, and we can talk about whether NFTs are products later, but are these products are 100% authentic, and Nike claims that that creates some kind of claim or leads consumers to believe that Nike has authorized these products in some way, when it hasn't. And I guess the crux of all of these are the companies claiming that no one other than them can authorize or can say that products are authentic. And when I first read the Chanel v, whichever one was first, I think it was, I forget if it was The Real Real or What Goes Around Comes Around, I was struck that a company would make such claims, like we're the only ones in writing at least. And I've since learned that it's really not the only one making such claims. You know, Rolex is making similar claims. I wrote down the language, actually, they kind of tiptoe a little bit. With the necessary knowledge, skills, and technical know-how, official Rolex retailers are best suited to guide you through the range of available models, blah, 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 blah. So they're not explicitly saying
Right.
it. Maybe they're just being Swiss and getting most of the way. You know, Audemars is a bit more explicit about their watches, basically saying the authenticity of an AP watch can only be confirmed after examining it in our workshop. So this is not limited to Chanel, but I'm not saying that that makes it okay.
So I got to say, I mean, I'm looking at Amy because I'm just reminded of Amy's paper where she says, so authentication in the art world often depends on foundations, for example, or the representatives of an artist living or dead who can authenticate or not. And that authentication is, I guess, almost law in some respects. So when I hear these statements, the one by Rolex sounds different from the one by Audemars. So, and I wonder where Chanel falls on the spectrum. So when I hear the one from Rolex, I hear a kind of cautious statement about, we are better at this because we have resources. We have insight into our own products.
Mhm.
That's a factual assertion. It may be true, it may not be true, but it's a factual assertion. The other one that you read sounds more like a concept, which is authenticity is kind of, we as an institution are in charge of this in the way that Amy explained in her paper. In the art world, this is often the concept at play. Where's Chanel on this spectrum, do you think?
I think we can all guess. I think they generally are leaning more towards, we will help you. We'll make this decision about what is authentic. I'm garnering that kind of from the language that they use when it comes to restoring and repairing. They say things like, we're the only ones that can restore your bag in an authentic way. And so I'm assuming that that same view kind of parlays into this as
They can
well.
deauthorize.
Yeah, exactly.
I wanted
Sorry.
to pick up on the watches, because watches are actually really complicated for the purposes of trademark law, because it's actually an assemblage of a lot of different things going on in a single watch. And like any component part of a watch could be an authentic one thing or another.
Mhm.
Like in my paper on with Mark Lemley on customization of aftermarket goods,
So good.
you could use an authentic Rolex watch face or dial or the internal mechanism that makes the watch work. And if you repurpose from like vintage Rolex watches and recase it or something like that, or just use the casing and it has different internal mechanics, there's a real question as to what constitutes an authentic Rolex watch, or do you have to disaggregate the claims about the watch to say this is an authentic, Sari Mazurka watch containing an authentic Rolex mechanism. So there was a recent case that was really interesting, and I think it bridges the conversation about furniture and wine. Hamilton versus Vortic. Vortic was this new watchmaker that was using authentic Hamilton pocket watches and then recasing them as wristwatches and selling them as Vortic, but they contained the Hamilton logo, because guess what? The Hamilton logo actually appeared on the Hamilton pocket watch, and Hamilton sued and they lost in the Second Circuit because there were sufficient disclosures really that this was a different creator. And this all came down to like the traditional likelihood of confusion standard under trademark law, that a purchaser in this like luxury watch market knows what they're getting. They know they're getting a Vortic that contains a Hamilton and not just a Hamilton.
Was there a post-sale confusion claim? And I'm trying to figure out how that would
there's a
work.
legitimate one.
Yeah.
And I just wanted to tie
it's a
this back to the very
wristwatch.
beginning of our conversation where we were talking about the question of whether we assess authenticity as a sort of empirical question about the features of the product, or actually it's just about somebody's ability to sort of authoritatively sort of put the stamp of approval on it. I said at the beginning that, trademark law is kind of like very much at one end of the spectrum, which is like authenticity is about somebody putting their stamp of approval on something, except there's one really important caveat that I should have given then, which is once you've sold the product, right? In the after sale market, we've always sort of assumed like your chance to stamp it and call it authentic was before you sold it. And once you sold it, like that travels with it, right? And so then it's created lots of these difficult cases in the first sale context about like how much change can be made to a product before that is no longer good as an authentication, right? And so and those cases struggle with those things. They're trying to figure out exactly how much change is possible. To some extent, those cases, you can think about them as like, what are the boundaries of the product, right? So what is the watch? And like you resell a used car and undoubtedly by that time you've replaced a whole bunch of the parts in there. Does that make it no longer an authentic version of the car? So we struggled with that problem, right? But the Chanel cases are sort of interestingly different problem, which is really trying to take back the idea that once you've released a product into the world, you're done with your authentication, right? Which is them saying, no, for now and forever, it's only authentic if we say it is, right? And it doesn't really matter what else you are doing. And so like the weaker version, which is I think still problematic of the Chanel case is, if you claim as the real to say you're authenticating stuff, that is an implicit statement that you're affiliated with us, right? Because the world understands authentication to always relate to the trademark owner. So that's like an implicit statement that's subject to likelihood of confusion. The stronger version, which I think is bonkers to use a technical term, right? Is that just as a conceptual matter, it is just not possible for anyone in the world other than the trademark owner to authenticate.
Yeah, but I want to get back to that because as a conceptual matter, there is an assertion by IP rights in some cases themselves that authentication is really about a certain place or a certain time. So let me give you the example. So let's get back to Bordeaux. So if I make a wine, always get back to that. If I make a wine in California that is made with the same grapes, it's not simply that I can't call it Bordeaux. I can't, certain GIs are grandfathered in, so this is actually kind of complicated, but generally speaking, the concept is I can't refer to the place as a comparator, right? So I can't say this is Bordeaux style wine. Now, what message does that send about authenticity? What message does, for example, the use of copyright as a tool? In Europe, this is, okay, I talked about Vitra earlier today. They are using copyright. Why? Because unlike here in the States, where the useful articles doctrine limits the application of copyright to things like tables, in Europe, there really is no such break.
I like how you stated the useful articles document as if you know what it is right now. Those are not shovels.
Can I just, I'm just going to say one thing. It has been restated, and so we now know what it is. But in any event, I am interested in what messages about authenticity those legal regimes are sending in Europe with furniture, in around the world with GIs, with wine or cheese or any of those. Anyone want to take that on?
I mean, the super strong version, like, the actual GI rules in Europe, which don't allow those referential kinds of uses, which I think that would generally not be an accurate description of the US system because of the nominative fair use doctrine.
Right.
But those are, I think, go beyond authenticity. Those are more like, it's not even that it is an inherently false statement to say that something is like Bordeaux when it is not from Bordeaux, right? That it's just sort of not conceptually possible for something to be like another thing if it's not from the same place.
And on what authority is that assertion made?
The French authority, I think.
About copyright in Europe, what message about authenticity is that sending or allowing people to send about these designs?
Yeah. I think it doesn't really so much matter whether it's copyright or trademark, as Mark was talking about, but I do think it is a collapsing of ideas, and it's possibly a very strategic move. So in what I'm looking at, in the absence of intellectual property rights, to collapse these two. So what I didn't mention is one of the strategies that Herman Miller used was to create the George Nelson Foundation. So the principal of the George Nelson Foundation is Herman Miller's general counsel. The address for the George Nelson Foundation is the same address as Herman Miller, right? It's kind of a shell operation, which received all the rights in George Nelson's designs from his 93-year-old widow, had them transferred to the foundation. There were no rights. There was no rights to transfer. So by going from artist to widow to foundation to Herman Miller, there is a provenance that makes a claim to IP rights in the absence of IP rights, right? But the IP rights also kind of influence how we think about authenticity, about the person who can authorize has authority, has the author's authority. And I think it kind of messes up both worlds in a way, and maybe especially in design, where the idea of provenance of this lineage has the ability to create rights where rights have been expired, rights have been abandoned, rights never existed, in a place where maybe rights should be shorter, much shorter than copyright.
Okay, I want to leave some time for questions. So I wonder if people have them, and if so, will they step up to the mic, please, and ask them?
I have a question.
Go ahead.
So
Since
my
we're
question
waiting.
is, what's going on with these customization stuff? You know, a student was just showing me this webpage for 112s. You know, I don't know, anybody 112s? Where they have like mashups of Doc Martens with like strips of fabric from Louis Vuitton on them,
Oh,
or Birkenstocks with, you know, Prada or Fendi on it. And it's so clearly, and they say they are using all authentic materials. But, you know, I think there's definitely something to status when consumers want the authorized or authentic good. But then there's just, I don't think that's it, right? I think it's such a mashup that it's clear it's not, you know, it's not coming from Louis Vuitton. So what is the brand doing there?
I mean, there's certainly value in knowing that the base of this like final product is an authentic Nike shoe, or that it uses authentic fabric that was once part of a handbag or something like that to be tassels on this shoe. But there's also value in it being from a certain customizer these days
Mhm.
also, because there are these like customization houses like Mischief that have sprung up. So there's value in having a Mischief customized Nike sneaker. And it's really hard to separate where the value comes from. You could kind of guess based on buying a $90 plain Nike shoe versus a $600 or $1,000 customized version of it, that the value comes from the customization and not the Nike shoe. But when people on the street look at this shoe, we have to wonder, what do they think they're looking at? Do they think they're looking at a Mischief shoe? Because there's so much publicity around Mischief shoes, I think it's fair to say yes. But for these smaller customizers like Drip Creations, which was the subject of a lawsuit, when someone on the street sees a Nike Air Force One that has Chester's the Cheetos cheetah drawn on it, do they think it's a Cheetos Nike shoe? Do they think it's a Nike shoe licensing the cheetah image from Cheetos, or do they think it's a Drip Creations? And a lot of that has to do with how saturated these brands are in our culture, and kind of which carries the weight in terms of establishing its identity and pervading the conversation about like sneaker culture in particular.
Yeah. I think it's interesting too, because collaborations or tie-ups that we wouldn't have thought we would ever see 10 years ago are really pervasive in the market. Like, it's not unheard of that, you know, it's not unfathomable that Cheetos would collaborate with a mass market shoe company, because it's just that weird right now.
You know the Chunky
know?
Monkey,
Yeah.
the Chunky Monkey shoes? It was a Ben & Jerry's collaboration
Yes.
licensed with Nike, and it came in a gallon-sized Ben & Jerry's container.
So this is, just to add, I mean, this is a little bit of a hobby horse of mine, but so I think that this is actually all a function of the fact that so trademark law now considers as infringing any kind of confusion about sponsorship or affiliation. Those are terms that have incredibly wide berth that have never been precisely defined. And in a world where all these collaborations are conceivable, which I think increasingly is true, it feels more like these cases are just pure questions of like, should people get to do that or not, right? It's not really an empirical question about confusion, because if you're asking 15% of the people, can you imagine that there's a collaboration here? The answer is always yes.
I just arranged a collaboration between an athletic shoe manufacturer, a very high-end boutique, and a smoked fish purveyor. They collaborated on a shoe. I
Super
love
interesting to know what
that.
that shoe looks like.
I'm just saying, it's
What
like
it smells
collaborations
like.
are
Even more important.
so, okay. So questions from the audience. Jeremy.
So two questions. The first is, why haven't you talked about merchandising? So merchandising, right, is obviously something that is a long history of trademark scholarship. Merchandising, I mean, university or sports team branded clothing and things like that. Authenticity obviously plays a big role there. And compare that to the role of, say, Bordeaux or Mr. Shoes. And the second is, what if different consumers have different conceptions of what is authentic? How does or should the law arbitrate with this?
Those questions are connected to.
Yeah.
I'll take a second,
Okay.
but you can go first.
I was just going to say something about the merchandising thing. So, I mean, all the original merchandising cases are courts just making it up, right? I mean, so there was absolutely no way it was empirically true in the 1970s that consumers thought T-shirts that had logos from universities on the front of it came from the university. In fact, and we have good evidence of that because we know in lots of those cases that it was longstanding practice in many of the college towns that nobody really cared about or tried to do anything about. And then all of a sudden, some marketing agents were like, we should be making more money on that stuff. And if you read those cases, like, I mean, the University of Wisconsin bookstore is my favorite target here, that the case at the TTAB, because it's just like a joke as a matter of law, right? They just run over like 3 bedrock trademark doctrines because they're like, we want the universities to have these things. But this is sort of like the problem with trademark laws. They may have created a world in which now everybody's expectations are that there is actually a licensing relationship. Now, maybe they only think that because they think the law requires it, right? And they don't actually. So on the authenticity question, I think it's always authentic as to what, like, you see a university T-shirt that has an Under Armour logo on it. Nobody thinks the university is the one deciding the thread count there, right? Or deciding how the T-shirt's going to perform. That's why they have Under Armour to do that. But they probably also think Under Armour needed a deal, right, with the university in order to do that. And so the authenticity is really entirely about the image. It's not really about the goods themselves. It's like another way in which trademark law has sort of moved away from or ignored the sort of inherent connection to the nature of the goods. But interesting question now, can you put the genie back in the bottle?
So I went down a rabbit hole and went onto Reddit to discover this whole world of subreddits with the word reps, either sneaker reps or rep sneakers. Those are 2 different communities, and there's reps everything, which is about the replica world, so it's a vast number of people, very, very active subreddits. And it is consumers, it's user-generated information trying to make transparent all the multi-level goods that are available in the market that are not authorized. And so there's lots of different opinions about what it means to be authentic. They've created their own language system, which is all cool. To indicate what is things of good quality. So there's such a thing as super fakes that are indistinguishable quality, very expensive, but still a reduction. And I think there's something really positive in that. Like it indicates that there is a broad market, and so this is something that the kind of real fake dichotomy collapses, right? It means there's a premium price. And then everybody else is racing to the bottom to have the cheapest counterfeit, right? And that is certainly not what's out there, and consumers know it.
More questions? Yes, Brian.
I wonder if maybe part of the problem is that much body of law regulated markets such as typically traditionally trademark laws consumers, but for example, in a market like the art market, for financial investments with artifacts. Here. And I just wonder if part of, maybe we just can't use or shouldn't necessarily think of the same body of law is designed to regulate in the appropriate way.
No.
It's almost like you were
I-
spying on our lunchtime conversation. We were talking just not. Go ahead, sorry.
Oh, I mean, I'm very sympathetic to the question because trademark law is used very expansively by brands to protect streams of revenues, basically, and to stake grounds for new revenue streams, like what we're seeing in the NFT space. These suits are really prospective, trying to build out a set of rights that don't currently exist in trademark law. And there's a really messy intersection between trademark law and trademark rights and culture and creative expression on the other hand, and it butchers how it treats art in general, whether it's about the investment aspect or just like the communicative aspect of art. And so I am on board with you that it really forces you to rethink whether trademark law should recede in this space rather than be more aggressive and kind of make it even more complicated and harder to know what your rights are or what they should be.
Authenticity or IP, but not both. Choose one.
Yeah, but they're inextricably intertwined at this point, right? So, it's in everything. So now American manufacturers of furniture are making bids, and the Ninth Circuit basically just remanded a case that seems to be going in the direction of Herman Miller to establish trade dress rights in the design of mid-century modern furniture, right? So that's a whole nother frontier, right, that has been occasionally, gestured at, but mostly not used, right? But maybe now that's about to turn a corner. So the idea is over time, people look at a chair, it could be a Charles Eames chair, and they start to form the expectation that the chair comes from one place. And so if that's the case, then the shape of that chair is a source indicator. So the company that used that the most is a company called Emeco in Pennsylvania, which makes the Navy chair, which is this aluminum chair. It's ubiquitous. You see it all over the place. It's available in many copies traditionally. But Emeco has brought lawsuits and has settled them on favorable terms with pretty big companies like Restoration Hardware, for example, and Target, on the idea that the shape of this chair, which they didn't design, which was designed actually for the US Navy. And the marketing for this is amazing. It's like they say this chair was designed to withstand a torpedo hit. And
But it's not at all functional.
right,
Sometimes.
my reaction was like, A, it's functional, and B, when is a torpedo going to hit my house? Because I don't care if the chair withstands it. My only concern is I'm not going to be there, right? But this is the next frontier, right? And this is an authenticity claim that this shape is authentically associated with this source. So they're inextricably intertwined.
So, but there's a smaller legal news going in the other direction, which is the TTAB just decided a case involving the Eames plywood dining chair,
Right.
which Time Magazine called the design of the century. And there they decided that they could not separate the function from the design. And that's exactly what Charles Eames would have always said, is that there's no such separation of design from function. So.
Guess I'll just add one thing about the product configuration cases have always been confounded by this problem of like, when you think about the secondary meaning, do you really think that that means secondary meaning in the sense that consumers think that physical thing comes from a particular source? Or are you really just saying you identify the design with a particular designer? And I don't think courts in any meaningful sense try to tease those two things apart, nor do any surveys that I'm aware of actually try to get at the difference between them. But actually, it's an enormous difference from at least the conventional way of thinking about trademark law. One of those things, at least as trademark law has recently evolved, is sort of in the bucket. But the other thing should definitely not be, right? Sort of this emanates from a particular source. I mean, especially like that ought to be a bunch of Daystar litigation about those kind of things. If it's just about the abstract design as an intangible thing, as opposed to the physical. Problem is when they start to control production of the physical, it's just like those two things run together in a way that make it hard to pull it apart.
Okay,
So.
we're kind of time for one question if there is one. Yep.
Do you think sneaker brands are overstepping or pushing trademark rights too far and interfering with artists' ability to use sneakers as canvas and transforming sneakers in that way? Could a paper company with a brand on the watermark sue an artist because the mark is still on the product? That's
I love that you said overstepping. Yes, and I would say yes to your question. And I think it's really hard to separate in your mind or for the purposes of law, a 6-year-old using a Hanes t-shirt and tie-dyeing it and selling it in the school fair from an artist drawing clouds on an Air Jordan and then reselling that in commerce. Like, you really have to dig deep to try to justify treating those two cases differently. And part of it, I mean, a large part of it is from the kind of brand exposure, the fact that you can't look away from the AIR on an Air Jordan or the swoosh on a Nike shoe, whereas the Hanes logo is internal, or like the Blick watermark is on the back of a canvas. But Nike is trying to stake out some real ground in trademark law. It said in its suit against Drip Creations, effectively, that they have an exclusive right to customize. They have an exclusive right to downstream uses of their products, which is just ridiculous when we think of the way we use consumer goods. And if you put a bunch of stickers on your MacBook and then you sold it on eBay, are you infringing Apple's trademark by engaging in that sale? Like, your gut tells you no. And if Apple were to assert that claim, it would be an expansion of trademark law and not a very like straightforward application of the state the law is in today.
All right, we've got to wrap it up. Thank you so much, everyone.